one of the courses that we teach under the umbrella of the summer school at Utrecht University is called Understanding and Managing Corporate Mergers and Acquisitions. Now, what do we mean by that? Of course, you know, when you read about it every day in the newspapers, that we focus on how firms get together, the one firm acquiring the other firm, or sailing further together into the future as a joint venture. Now, in this course, in this particular course, we set ourselves two things as goals. One is to understand why these mergers and acquisitions take place, and secondly, after they have taken place, how we could best manage them to success. Now, you would be inclined to say, well, mergers take place because strength grows from size. So firms get together, they will become more efficient, they will become more market dominant, they will become more profitable, they will generate more shareholder value. The interesting fact of having a course taught by professors that have also done research, field research in these questions, is that the answer is not so easy. In many cases, especially when we look at firms that are quoted on stock exchanges, there is no growth in shareholder value. There is no growth in efficiency. There is no growth in productivity following a get-together of firms under one roof. So this begs the question, why at all would these firms get together? Well, that is a long answer, and the long answer is not just taught in the course, but it also has implications for the way in which these mergers are managed after the fact. It also has implications for regulatory oversight, that is to say competition policy in many jurisdictions, or antitrust policy as our American colleagues would say. Merger control in Europe has become a large outfit in the work and the task of the European Commission, for example. And we will try to address the issues that are relevant for setting out an efficient merger control policy. Now, to tip one part of the mystery is to say that it has been shown that a lot of mergers and acquisitions take place because a lot of mergers and acquisitions take place. This sounds like an epidemic, and indeed, the models that have been used in describing merger and acquisition intertemporal dynamics have been borrowed from the same models that are being used in the current pandemic to describe, to map the pandemic. That is to say, there's a lot of contagion going on. And contagion is not just something that refers to COVID-19, it's also something that refers to what firms do and think they should be doing. Now, this is a very interesting development. It's a very topical development, and it's because this course is the result of a collaboration between legal experts, economic experts, and business experts with field experience, in which we address this issue, whereas this is almost not addressed anywhere else.
Obviously, next to economic issues, you have a lot of legal issues when you're dealing with mergers and acquisitions. Actually, the task of a lawyer is to divide the risk between parties, between the buyer and the seller. They have to draft several documents to make sure that the parties understand each other well and the deal gets finalized. One of these documents at the beginning is the letter of intent. Another important document, obviously, is the share purchase agreement, the SPA. And when you have several buyers, in many cases you have also a shareholders agreement. When you deal with a public bid, a bid on listed shares, a deal concerning listed shares, then you need even more documents. In this course, we'll explain to you what kind of documents these are and how you draft such a document. What's new in this version of the course is, of course, the influence of the COVID-19 crisis. You can do something with that. It's also part of the risk you have as a buyer, and there are special clauses for that. They're called MAC clauses, material adverse effect clauses. About this very interesting subject, we have a special lecturer, Tishanti de Jonge, an experienced mergers and acquisitions lawyer, who is going to lecture about that.
Imagine, it's January 2020. You have already graduated, and a couple of months before, you've landed yourself a job at a prestigious private equity firm. You are their newest M&A legal counsel. And after working through Christmas and New Year's, you finally signed your first transaction. With your help, the PE firm has acquired a chain of very popular but cozy restaurants. And with cozy, I mean that there are as many small tables per square meter as possible. The purchase price was quite high, but that was not an issue because it's January 2020. Money is still cheap, and the deal is highly leveraged with a bank loan. The business team is also very confident that they can expand the business and open many more restaurants in the next 4 to 5 years, and then sell it on to the next buyer. Before closing can occur, a few conditions precedent have to be fulfilled, but you expect that that will all be taken care of in the next couple of months. Now let's fast forward. It's mid-April 2020. Almost all conditions precedent have been fulfilled and closing is in sight. The deal you were so proud of in January 2020 is about to close. But the world looks quite different today. The country is on lockdown and most restaurants have been closed. There's no money coming in. And in the past couple of weeks, the financial results of the company that you are about to acquire are not that good. You get a call from the CEO of the private equity firm. His message is very clear. Get us out of this deal. I don't want to buy this company anymore. You fix it. So, what can you do? Are there opportunities in the SPA or under Dutch law based on which you can terminate the contract? Or maybe at least renegotiate the terms thereof? What are the tools you have? At the M&A Summer School, you will learn what legal tools a purchaser may have in the event that in the period between signing of an SPA and closing of the transaction, an event such as the COVID-19 pandemic happens. We will look into 2 legal tools. The first is the MAC clause in the SPA, the material adverse change clause. And the second is the Dutch contract law concept of unforeseen circumstances and its impact on contracts. During the M&A Summer School, you will learn about the different types of MAC clauses, the interpretation thereof, national and international jurisprudence, and whether an event such as the COVID-19 pandemic qualifies as a material adverse change to the business, the company, or the operations of the company, all depending on the wording of the actual MAC clause. After we have explored the opportunities of a MAC clause, we will look into section 258 of Book 6 of the Dutch Civil Code. Based on that section, a party to a contract may request a court to modify the contract or its effects, or even dissolve a contract in full or in part, in the event of unforeseen circumstances of such nature that the other party to the contract may not expect, based on the principles of reasonableness and fairness, that the contract will be maintained unmodified. Together we will explore whether all requirements of this section have been met in case of the COVID-19 pandemic. After the M&A Summer School, you will have a full understanding of these 2 tools, and you will be able to explain to the CEO of the private equity firm whether you have a solid case if you want to try to terminate or modify the SPA based on the COVID-19 pandemic.
Hello everyone, and thank you for your interest in some additional courses we offer here at Utrecht Summer School. My name is Luigi Pina, and I've been teaching at Utrecht School of Economics for 10 years. I've been involved with the summer program here for another 4 years. Prior to that, I was working for 28 years in a large US multinational company in both corporate governance and my next topic, which is mergers and acquisitions. I spent the last 10 years of my career selling and buying companies for my parent company. Very exciting field, because mergers and acquisitions, they've been running into almost $4 to $5 trillion a year worth of business. The most expensive things large companies do these days are buy and sell themselves. And why is this going on? Why are they not investing in R&D or hiring more people? Because now it's just basically a market for which companies can become bigger, healthier, expand markets. It is based on strategy, first of all, about how you can develop the business of a company. And a lot of times you do it by entering another country, entering another market, entering another business. This has been going on for quite a while, but it's really picked up speed lately. And some of these companies that do these deals, they realize that they're only financially successful less than half of the time. In some cases, only 25% of the time. You may have heard a previous explanation of the merger paradox, where why do they spend so much money doing something that has a low success rate? Well, like another course we do, corporate governance, it's because a lot of these decision makers are using other people's money to further their own agendas. So it's a lot of corporate behavior type things. But in many cases, mergers and acquisitions have been going on for a long time. They will keep going on, but we're going to focus some things on the new companies that are involved in doing this. You probably heard about oil companies merging, car companies, things like that, but there's really a lot of activity going on in a couple of fields such as pharmaceuticals and portal type IT companies, intellectual property companies, companies that don't really produce much of a hard product, but have been growing tremendously, have tremendous power, influence, and financial wherewithal to really go after some big deals. Now, we're doing these as remote teaching, and what's kind of interesting is, even though the economies have been hurting, the whole size and interest in mergers and acquisitions has not. Mainly because most of these companies that can afford to do deals, they haven't lost their money. If you're talking about portal companies, these companies are not closing shops because a lot of times they didn't have a physical shop to begin with. So who's best positioned when we come out of this COVID situation to hit the ground running even faster than anyone else did before? We'll look at those kind of possibilities. We will have a lot of case studies of companies that are very successful in certain mergers and acquisitions. You may know some very good ones. Disney buying Pixar was an excellent idea because 9 out of the 10 biggest grossing movies for Disney in 90s and early 2000s were Pixar movies. So why not buy the maker of, why not buy the goose that laid the golden egg? Ones that didn't work too well, AOL Time Warner, disaster, but maybe more familiarly when Benz tried to bought Chrysler and it was a disaster. Oh, how about when Fiat and Chrysler merged together? How come that was successful? Because of several reasons, which I think you'll be interested to find out in such a course. I hope you pursue looking into this, and thank you for your attention.